Today, we're going to pay attention. We're going to be on the Bureau of Prisons website and First Step Act frequently asked questions. General information about the First Step Act as it relates to the Bureau of Prisons, the inmates, and their families. So I'm going to go through these. There's about a dozen topics. What is the First Step Act? The First Step Act was signed into law in December of 2018 with provisions that impact the Federal Bureau of Prison inmates and their families. The law gives judges greater latitude in imposing mandatory minimum sentences. It allows inmates to earn increased good conduct time. It increases the Bureau of Prisons recidivism reduction programming to address inmate needs. It offers earned time credits for completion of these recidivism reduction programs and/or productive activities, and it expands opportunities for inmate placement into residential reentry centers or direct to home confinement. Now, we all know that this is actually the latter part of that is not happening, but good time credit, greater latitude or minimum sentences, increasing good time credit right here. Good time credit now is 54 days off your sentence a year, but it's given to you up front. And so, as long as you have a sentence greater than a year and a day or greater than a year, you're going to qualify for good conduct time as long as you don't get in trouble and lose your good conduct time. Recidivism programming. There are programs, a number of programs that each of the Bureau of Prisons has. And before you get to your pre-sentence interview, is probably when you should be taking several months and preparing. A part of the preparation is identifying a prison for you to be able to choose or to request that the judge places you in, and it needs to be based on reasons. Now, the reasons can be on a medical reason, it can be on specific types of programs, it can be on vocational training. If you have an interest rather in, in HVAC training, to understand those systems, well, by knowing which prison has which programs and credit and gives you accredited, training, can help the judge work with you and your attorney to grant whatever placement request. Applicability of law. Do military or state offenders benefit from any of the provisions of the First Step Act? The risk and needs assessment system is used to assign all inmates to a risk recidivism category, and their needs will be assessed. Now, I've already suggested in other videos that they're supposed to do this within the first 28 days of being incarcerated. That doesn't always happen. Eligible inmates will be able to learn First Step Back time credits. However, military code and or state offenders will not be eligible rather to earn these First Step Back credits as the law states right now. It's only for federal offenders. Additionally, the Second Chance Act home confinement pilot program made changes with 18 USC 3582 related to compassionate release program again, but it's only to federal offenders. And part of it can be there's a list of things that qualify, but part of it can be if you're over the age of 70, you've served a greater percentage of your time in prison and you haven't caused any problems. If you have a medical need and the medical needs haven't been addressed, and it could affect you health wise to your detriment, you can go from what's called a administrative remedy process to the warden, and they'll go directly into the court system. However, the BOP will consider military or state offenders for pre-release custody in accordance with existing BOP release preparation policies. Generally, these policies address management of the inmate population, such as prohibition against restraining pregnant offenders, the provision of sanitary products made available to female offenders, which it's been all over the news lately, and this is February 2 of 2026, that some of the commissaries just don't have these supplies. Providing assistance for release preparation and obtaining identification and increased privileges for inmate participation in programs and productive activities will be applied to all persons in the BOP custody, including military and or state offenders. So you may have access to the programs. I'm not sure if this means that if you're a state offender, you're going to be able to get early release credit for it. But that's a question that I need to address at another time. Compassionate release under the First Step Act. How did it change? Under the First Step Act, an inmate can now file for a reduction in sentence, RIS, known as compassionate release, directly to the court, which I just said, 30 days after making the request to the BOP, which is your warden, or after exhausting the administrative remedy process. This means that there's a bureau, it's called a BP9, goes to a BP10, BP11, and then you can go to the court. If it's a medical compassionate release, you could just go to the BP9, 30 days, and then go right to the Bureau of Prisons, right to the court. This is the program statement that comes up with it. And see compassionate release, just look for this program statement. Number 5050.50, July 17, 2019, compassionate release. Back to here. What are the options for terminally ill? I covered that a bit. A terminally ill offender may apply for compassionate release. Additionally, eligible offender may apply for Second Chance Act home confinement pilot program to be placed in home detention until the expiration of their prison term. We found that the Bureau of Prisons has been hesitant to let inmates go, and such to the point where Federal Judge Dalton, I forget the inmate's name. He was, I believe, I don't remember the prison he was at either, but essentially the Bureau of Prisons refused to let him go to home confinement. Had cancer. He was dying. He could not, do he had no activities of daily living. He was hospitalized. And by the time he got home, he was dead within a week or within several days. And so, it's pretty important to understand this, but also to get help from your loved ones at home, which I approach on my website. How can an inmate apply for compassionate release? Inmates who meet the eligibility criteria may apply for a compassionate release consideration by making the request to their unit team. The request will be reviewed by the warden and ultimately by the BOP director, whether approval of the request is appropriate. Now, mind you, the inmate, when it goes to the warden, it's a BP9. The BOP director, this is all the way past at a BP11. So there's a BP10 in there. More important information about the Bureau of Prisons RS process, including eligibility, can be found on this same program statement, 5050.50. The same one as right here. Additionally, on the First Step Back, an inmate may now file a motion for compassionate release directly to the sentencing court 30 days. And again, I already said this, I mentioned it, after making a request to the warden of the prison. And if it's a medical emergency, you can go right to the court. Otherwise, you need to exhaust the administrative remedy process. Distance from home. Several YouTubes have addressed this. The First Step Back requires the Bureau of Prisons to designate an inmate to a facility as close as practical to the prisoner's primary residence, to the extent practicable, and a facility within 500 driving miles. Now, recently, they've been using as the crow flies. The BOP's determination is based on a variety of factors, including bed space, availability, inmate security level, program needs, mental health care needs, any request made by the inmate related to faith-based needs, recommendations of the sentencing court, and other security concerns of the Bureau of Prisons. The Bureau will consider inmates for transfer even if they are already within 500 driving miles of their relief residence. It is important to note that the BOP's designation decisions are not reviewable. Everything is at their discretion. We'll open this, and you will see that the imprisonment of a convicted person, this is crimes and criminal procedure, but it goes through what is required. But it boils down to it's at the discretion of the warden of the Federal Bureau of Prisons. Can families make requests to have an inmate move closer to primary residence? Requests for transfer must be initiated by the inmate. The Bureau of Prisons is required by the First Step Act to consider an inmate's preference for staying at his or her current facility. That is wonderful. And this is the law. And in these program statements that I review, for example, this one up here for compassionate release, these program statements are the Bible and the law according to the Federal Bureau of Prisons. What do you do, though, if the individual is so ill that they're not able to do this on their own? There are things you can do, and it starts with getting, the family involved at home, possibly legal. Early release. How can an inmate obtain early release or additional community custody time, home detention, or a halfway house under the First Step Act? An inmate may file a motion with the court and receive a reduced sentence under the Fair Sentencing Act revisions. In this, Fair Sentencing Act 2010 is defined as reduced the statutory penalties, for example, crack cocaine, to reduce an 18-to-1 crack powder drug quantity ratio. It also eliminated the mandatory minimum sentence for simply possession of crack cocaine and increased fines. Provisions, including the First Step Act. Please see Fair Sentencing Act questions and answers. We'll open this up here. And I guess we're not going to do that there. Sorry about that. 2, an inmate may earn time credits for completion of evidence-based recidivism reduction programs and/or productive activities if they were not convicted of a non-qualifying offense. So there are offenses that are just going to take you out of the loop where you can't apply or take advantage of these programming. And some of them are if it's a crime of violence, guns, etc. What you can do is if you have a very, very high pattern score and you set your sentence to 10-year plus, 20-year, 30 years, you can begin to work your way down um, while you're in the facility, and you won't earn time credits, but you can take the First Step Back programs. And I have articles that are throughout my website, YouTube's rather, that show that people that have had life sentences have been able to walk out of the prison free. An inmate may be approved for compassionate release, also known as a reduction in sentence, based on extraordinary compelling circumstances, such as a diagnosis of a terminal illness, debilitation, or other criteria. Again, we go back to the compassionate release questions that was on that program statement. The challenges here is that getting access to medical care may be it's written on paper that we have access to medical care, but the literal ability to access that care where there's a terminal illness diagnosis, a debilitation of the individual, that may not be equally for all. There are times where the clinical director at a Bureau of Prisons facility may grant you a second opinion at it with an outside consultant who's not he's not a prison employee, the regular physicians. When you come back to the prison, the clinical director in the Bureau of Prisons is not obligated to follow those recommendations from their specialists. An inmate may request participation in the elderly offender pilot based upon their age and length of time served. And again, it's over the age of 70, and I think it's 75% of your sentence, but I'm not 100, I don't recall exactly. But here's the answer. Good conduct time used to calculate eligibility for the elderly offender home confinement pilot program. An inmate is considered eligible for the elderly offender home confinement program if he or she has served 2/3 of the term of imprisonment for the offender that was sentenced. This calculation does not include the application of good conduct time. There is also an age determination. I believe it's 70, but I don't recall exactly right now. How do you apply for early release under the Fair Sentencing Act? The Fair Sentencing Act provisions of the First Step Act authorize the defendant, the Bureau of Prison Director, the prosecution, or the sentencing court to move to reduce an inmate's sentence if the offender's offense is covered under the Fair Sentencing Act of 2010. Defendants are not eligible if they previously had a sentence imposed or reduced under the same Fair Sentencing Act of 2010 or had a prior motion denied. And so here, Fair Sentencing Act is covered under 841B1 and B1, B1A, B1B, small b1, 960, and 960b2. So rather than opening these up, they're available for you to find on their website, but I'll just click on one so you get to see. And this comes up, 841, the prohibitive acts, unlawful acts, penalties. Let's go back. Is the Fair Sentencing Act retroactive? Yes. First Step Back made the Fair Sentencing Act of 2010 retroactive, which means that inmates whose offense was committed prior to August 3, 2010 may be eligible for sentencing reduction as if the Fair Sentencing Act was in effect at that time. Continuing, Unicorn. How does the First Step Act expand inmate employment? Through the FPI. The First Step Back authorizes FPI, which is a trade name of Unicorn, to sell products to new markets. Public entities for use in penal or correctional institutions, penal entities for use in disaster or emergency release, the District of Columbia government, and for products other than office furniture to tax-exempt nonprofit organization. These new authorizations will help Unicorn increase inmate employment skill building opportunities. For more information, here's a website to Unicorn. I'll open that up just so you see quickly. It goes into Unicorn and the skills that you can learn. Will the BOP increase the number of jobs available through Unicorn? These expanded authorities under the First Step Act are expected to assist Unicorn to increase inmate employment. Again, they direct you back to the website. Practically speaking, there's not enough staff in the BOP right now to create more jobs to supervise individuals. So I'm not sure of the validity right there, but it doesn't seem possible, but I can be wrong. Good time. How did the First Step Back calculation of good time credit change? Prior to First Step Back, inmates earned up to 54 days of good contact time each year served in accordance with 18 UHC 3624B. The BOP prorated the amount of good conduct time earned for the final year of service of sentence. Under the amendments made by the First Step Act, inmates would be eligible to earn the same 54 days of good contact time posed by the court, but it's posed up front. Will the inmate still earn good conduct time if they are not eligible for time credits? Yes. All inmates convicted of a federal offense committed after November 1, 1987 are eligible for the 54 days of good conduct time. When are the good time changes effective? The amendments made to good conduct time took effect July 19, 2019, and the Department of Justice published the risk and needs assessment system. Are the changes the First Step Act makes to the calculation of good conduct time retroactive? Yes. To the calculation of good conduct times are retroactive. It means they apply to inmates who committed their crime prior to the enactment of the First Step Act, December 21, 2018. However, only inmates convicted of a federal offense committed after November 87 and inmates convicted of DC Code felony offenses committed on or after August 5, 2000 are eligible to earn that up to 54 days of good conduct time. Are BOP inmates who are ineligible to benefit from the good contact time changes are there BOP inmates who are ineligible to benefit from the good conduct changes under the First Step Act? Yes. Not all Bureau of Prison inmates are eligible for the changes in how good conduct time is calculated. Only inmates convicted of a federal offense committed after November 1, 1987 and inmates convicted in the Washington, D.C. area on or after August 5, 2000 are eligible. Continuing, home confinement. Are there statutory limits on home confinement? The answer is yes. Generally, inmates who are ineligible to earn qualifying time credits may only be placed in home confinement for the shorter of 10% of the term of imprisonment or 6 months. Inmates participating in Second Chance Act home confinement pilot program may only be placed on home confinement if they have served 2/3 of their sentence. Identification. What's the BOP doing to ensure inmates receive identification before release? The Bureau of Prison Policy already directs staff to assist inmates in obtaining identification prior to release. Specifically, inmates are provided reasonable assistance in obtaining a Social Security card, driver's license, or other official photo identification, and a birth certificate. I don't know how often that happens, but the Bureau of Prison now has been producing a laminated card. It states, I believe, are authorized to use. It's kind of like a driver's license, but it's not. It's just an identification card. Inmate needs assessment. What inmate needs does the BOP assess during the intake at the team meeting? The BOP assesses inmates for the following needs: anger, hostility, antisocial peers, cognitions, dyslexia, education, family parenting, work, finance, poverty, mental health, medical health, recreation, leisure, fitness, substance abuse, and trauma. If an inmate is assessed as having one or more of these needs, the unit team will assist the inmate in setting goals for these programs. What is the criteria used for medication-assisted treatment, MAT? Well, this is not a good answer. Diagnosis of an opioid use disorder, ICD-9 or ICD-10 at this point. This is made before you even go in to the into prison. But inmates are screened, and you're only screened 6 months before you go to a halfway house or residential reentry center. So I don't know if you're going to be getting treatment while you're in prison. I don't have an idea. As it is, a lot of the facilities either don't have the medications or they're trying to move from injections to strips that they give to the inmate. The problem is that people are then stealing or selling those strips, and they're not helping the person. It's not as safe. It's more safe to be giving this medicated-assisted treatment to opioid individuals in person by needle. History of opioid is noted in mental health intake, positive urinalysis, self-referral. What does naltrexone injection do to a patient? It's extended release injection that blocks opioid receptors to the brain, interfering with the pleasure feelings associated taking opioids. It can significantly enhance the ability of inmates to resist opioid existing behaviors. But again, if this is true, where they're only going to be considering you 6 months before you get released, I don't get it. Do the residence reentry centers, MAC, naloxone treatment program, counseling, as well as medication administration? Yes. The residential reentry centers, MAT, medical assisted treatment, naltrexone program requires ongoing counseling for the duration of treatment. Counseling and medication administered are integral parts of the treatment plan, which means that if you go ahead and take the drug program, you're also going to have to spend at least 3-4 months when you're on halfway house under follow-up drug assisted program. Residential drug program. I think I just covered this. How does the First Step Act change RDAP? RDAP has not changed. Can an inmate benefit from both early release due to RDAP participation and changes to good contact time? And the answer is yes. Yeah, an inmate's projected release date will be adjusted due to the application of good conduct time changes, as well as the earned time credits from RDAP. Risk and needs assessment system. What is the risk and needs assessment system intended to do? The risk and needs assessment system is used to determine the risk of needs of inmates in BOP custody. Specifically, the system determines the recidivism risk of each inmate and assigns a recidivism risk score of minimum, low, medium, or high risk. This is pattern score. These are hard coded for most individuals, and if you're in prison a long time, you can begin to take yourself from a high and a medium risk to a minimum or low risk. This system also assesses each inmate and determines the extent practical inmate's risk of violent or serious misconduct. BOP staff use the system to determine the type and amount of evidence-based recidivism reduction programming appropriate for each inmate and to assign recommended programs based on the inmate's specific criminogenic needs. So if you're going into a minimum or a camp or a low, the first thing you should do is take your risk assessment survey on their computer system. Because if you do not, and they start giving you, classes and credits to take, you may take the classes, but you're not going to earn the credits. And so you want to make sure that you have gone through that risk assessment on the computer as soon as you get in or as soon as you can. What's the Second Chance Act home confinement pilot program? An inmate may apply for home confinement under the Second Chance Act home confinement pilot program provisions contained in the First Step Act if they meet the eligible criteria of as an elderly offender or a terminally ill offender. An inmate may request release under either provision within their unit team. More information about the Second Chance Act, and this we will open up. Error page. So it seems that this link here is not working, which is part of the course. All of their orientation and admission and orientation handbooks that they used to have online are no more. The eligibility criteria for participating under the Second Chance Act home confinement pilot program, eligibility elderly offender means an offender in the Bureau of Prisons who is less than 60 years old, who is not less than 60 years old, and has served two-thirds of their sentence. Eligible terminal ill offender means an offender in the custody of the Bureau of Prisons who's been determined by a medical doctor approved by the Bureau of Prisons to be in need of care at a nursing home, intermediate care facility, or assisted living facility, as those terms are defined in Section 232 of the National Housing Act. Diagnosed with a terminal illness. Due to the changes in staffing at the BOP and the fact that some prisons are left with one doctor for, I don't know, almost 1,000 inmates, we just don't know. So it's important to understand your position before you go into prison. And if you're in prison, then to have someone on the outside contact me, contact someone else to be able to help you make these determinations. Can an inmate go straight to elderly offender home detention? Do they have to go to a residential reentry center first? Inmates approved by the POP, Bureau of Prisons, for the Second Chance Act home confinement pilot program, provisions of the First Step Act may be transferred directly from the institution to home confinement. They do not need to go to a residential reentry center or a halfway house. Can an inmate apply for Second Chance Act elderly offender pilot program before his actual eligibility date? Inmates should apply for the pilot program when they are within 6 months of eligibility or have served two-thirds of their sentence. Applications made before that will be returned. So even when a judge orders the Bureau of Prison to release, they don't always release. And so having to wait until the 6 months or two-thirds of your sentence is not in concrete, but you just need help from the courts. Time credits. Who's eligible for time credits? The First Step Act provides eligible inmates to earn time credits if they participate and complete assigned evidence-based recidivism and reduction programs or productive activities. An inmate is eligible to earn credits if he or she was convicted of a U.S. federal code offense. He or she was not convicted of a disqualifying offense. He or she is at an institution, but not in disciplinary segregation. I'm going to open this up and see if it opens up. It actually does. And it goes to a plethora of things that will make you ineligible, disqualifying offenses. Can an inmate begin? When can they begin? First Step Act credits may only be earned for completion of assigned evidence-based recidivism reduction programs or productive activities successfully completed on or after January 15, 2020. Eligible inmates will be afforded a presumption of participation and awarded First Step Act calculations for the period from December 21, 2018 until 2020, excluding any period in which they were in a special housing unit, isolation, the SHU, in a designation status outside or away from their home BOP institution or for refusing mandatory programming. These may not be earned after the inmate's term imprisonment begins, until the inmate term imprisonment begins. The inmate's sentence begins when the inmate arrives or voluntarily surrenders at a designated facility. Because the ability to accrue time credits after the inmate's current term incarceration begins, an inmate cannot earn these credits during pretrial confinement, nor can they earn credits based on prior incarceration. Also, inmates cannot earn these credits between the U.S. Marshal Service custody, regardless of where they were housed. Will deportable aliens be eligible to earn these time credits? Deportable aliens may be able to earn these time credits, but they are not eligible to apply these credits towards their release date if they are subjected to a final order of removal under immigration laws. Who's eligible? Time credits may be applied by the Bureau of Prison to place an inmate in pretrial custody in the community or supervised release if an inmate is assigned a minimum or low recidivism risk in the last two assessments. The Bureau of Prisons may apply these earned credits in an amount that is equal to the remainder of the inmate's imposed term of imprisonment. Inmates assigned high or medium recidivism scores may also be considered if the warden requests the transfer after determining that the inmate does not pose a danger to the community and is unlikely to recidivate and has made a good faith effort to lower their recidivism risk scoring through participation in these recidivism reduction programs or activities. The Bureau of Prison director may transfer an inmate to begin a term of supervised release. Most federal sentences include some term of pardon or supervised release. The main difference between pardon and supervised release is that the probation is served instead of the prison sentence. The BOP director may transfer an inmate to begin a term of supervised release at an earlier date not to exceed 12 months based on the application of the time credits under 18 U.S.C. 3632. Time credits taken away, can they be restored? Yes, earned time credits can be taken away or restored. An inmate may lose these credits if they engage in misconduct or for violation of the requirements or rules of either of these programs, evidence-based recidivism reduction programs, or these activities. The procedures for loss of these credits are described in the federal regulations. The BOP or Bureau of Prisons will inform an inmate of any loss of these time credits in writing. The Bureau of Prisons will also reduce the time credits an inmate has to serve as of the date of the misconduct or rule violation. An inmate who has lost these First Step Act credits, either for misconduct or violating the rules of the evidence-based recidivism reduction or program activities, may have part or all of the First Step Act credits restored to him or her on a case-by-case basis. The authority to restore any portion of the defendant's lost credits is delegated to the warden and may not be delegated lower than the associate warden level. The inmate may request restoration of these credits during regularly scheduled program review and only after having maintained clear conduct for 2 consecutive risk and needs assessments. I hope you found this helpful. Let's see what else is here. Recidivism. The Bureau of Prisons has identified programs and activities for inmates to earn these credits. It may be applied towards pre-release custody. Inmates may access the latest approved programs and activities guides through the TrueLink system, which is the computer system in prison. What does it mean to successfully participate? Inmates are considered to be successfully participating in recommended programs or activities as long as they attend all of the sessions. I mean, it's that simple. If, additionally, must not occur. If someone's in the SHU, disciplinary segregation status outside the institution, they may choose to opt in or opt out. I mean, additionally, the following situations must not occur. Placement in the SHU, which is disciplinary status outside the institution, extended medical treatment in a hospital, escorted trip furlough, temporarily transferred to the custody of another federal, non-federal agency, placed on mental health psychiatric hold, or they choose to opt out. There are other choices here, but I'm running out of video record time. I hope you have found this helpful. The easiest place to find this is going to be First Step Back, frequently asked questions. You can get to it right from the first page. I thank you for taking this time. I know it's been long to listen. I appreciate your time, and I hope you all stay safe.